the Family Matters show. I'm Benjamin Bryant, a partner at Bryant McKinnon Lawyers here in Coffs Harbour, and today I'm joined with family lawyer extraordinaire, Gemma on my team, Gemma Rowe. Welcome.
Hello. Thank you. Ben, are educators and other professionals working with a child able to give information directly to a step-parent without the biological parent's permission? Does the law differentiate between a primary carer that is a step-parent and a step-parent that has the child for access with the biological parent?
Yeah, when I read this question, I think the question is as a step-parent, is it different if your partner is the primary carer for the children, or whether your partner is the other parent, or the parent that has alternate weekends or school holidays or whatever? I think that's what I meant. And like with the question before, Gemma, in this one, we really do need more information because there's nothing. Confidentiality is obviously an issue in this one. There's nothing in the Family Law Act which says, you know, this person is eligible for this information. It doesn't work like that. The Family Law Act does talk about parental responsibility, okay, whether there's orders in place or not, and obviously the focus on that is on parents, okay, and here we have a step-parent. It could well be that, you know, educators at the school, the step-parent might be noted as an emergency contact person, or they were involved in an enrolment person. They're a person that comes to the school and collects the child on a daily basis, or each Friday or something like that. And in those circumstances, I'm sure the school wouldn't hesitate to provide information or give a call or whatever's, you know, required. Likewise, in, for example, medical practices and doctor's surgeries and stuff, who's taking the child to the appointment, who's sitting next to the child when they're disclosing the confidential information, or who's on the Medicare card and things like that. So there's no hard and fast rule. There's nothing, you know, to say either way, and it really does depend on the relationship between the step-parent and the child and what role they have, and also the agency who the parents, in a sense, dealing with, okay? But there would be, if it was a brand new agency that the parents were dealing with, I dare say it would be, you know, common for step-parents to get some resistance from that agency as to, you know, who can share. You'd want more information about what it means, you know, without the biological parents' permission.
Yeah, does that mean they've actively objected?
Yeah, well, objected to who? That's the question, because the step-parent's partner, okay, of course, is the biological parent of the child, so that other parent can't stop them from getting information. So I'm not sure where the objection comes from, Jimmy, because your partner can get the information, you can share it,
other biological
but you're kind of cutting.
I
think this, you know, trying to cut out the middleman, okay. But there are, as I said, if there is any doubt as to parental responsibility, or if there is an issue, particularly when we talk about parental responsibility, we talk about major long-term issues. We're talking about schooling, where the child lives, religious, health needs, things like that. If there is any question about that specifically for a child for a variety of reasons, you can actually approach the court and seek specific orders in relation to either parental responsibility or the provision of information. Okay, so it is difficult to answer this one without having, you know, more information. So again, I would encourage this viewer who sent the question through to, of course, make contact and get some specific legal advice to them. If you have any questions along that line, along those lines, or any questions at all really for Ian Nesbitt, please send them through. You can email us at familymatters@bryantmckinnon.com.au, or you can send us a message on Facebook. And thank you for being with us.